So I know you'll forgive me for being in civilian attire here and coming to you today on a Sunday. Tomorrow, Monday, is a very important day in the state of Florida for our legislature, for our judicial system, and for property owners all across the state of Florida. Tomorrow, Monday, the Florida Senate will consider amendments to Senate Bill 1890. Senate Bill 1890 is the companion to House Bill 213, which is the pending foreclosure reform legislation. This morning I want to engage in another takedown of the legislation. I want to do it in a thoughtful and academic and, dare I say, lawyerly way, because I want to point out real problems here which demonstrate how if any legislation passes resembling its current form, it's going to cause us a whole lot more problems in the long run than we have right now. Let's understand what's happened here in this state. The laws that govern foreclosures have been consistent and relatively stable for hundreds of years. The documents that govern foreclosures and mortgage and ownership to property have been consistent and relatively stable for hundreds of years. The case law that we relied on to pursue foreclosures in the state have quite literally been around since the turn of the century without a whole lot of amendment or changes to them. I've got a long academic law review article that's coming up soon which demonstrates this. But the fact of the matter is that up until very recently, much of the case law that we were quoting and supporting in foreclosures occurred just after the turn of the century, just around the Great Depression, 1935, Johns v. Gilead, Conrad Scott versus Taylor, and with some few exceptions, that had been the law in this state since that time. But what happened? Through reckless and irresponsible conduct on the part of the banking industry, they have caused chaos in our court system. And what they seek to do now with legislation is to excuse an industry's conduct which has done nothing but dump chaos into our court system. I will submit to you that it is not the job of my legislature, our legislature, working for the citizens of the state of Florida, to excuse the conduct of an industry that acted recklessly and irresponsibly, especially when the law as it exists provides ample opportunity for them to fix their own problems. Let's understand something. Our courts, when they are properly funded, have the tools they need to address this problem. It's not so much a crisis anymore. It's a mess, and it's a mess caused by the banking industry. But it's a mess that our court system is working its way through. What this legislation seeks to do is excuse and gloss over the conduct of the banks. And quite simply, there are two ways that the current problems can be addressed within the framework of our existing laws. Number one, the cases that clog our system, in my county, Pinellas, it's estimated there are some 28,000 foreclosure cases that are stuck in the system. Now, the fact of the matter is that these cases are stuck in the system not because of foreclosure defense attorneys, and frankly, not because homeowners have filed any responses at all. The vast majority of cases that are clogged in our court system remain clogged there because the banks, the party that filed the lawsuit, are choosing not to move these cases forward. Now, they are the masters of their own destiny. Litigants in our civil litigation system, when they file a lawsuit, are in charge of the process of that case. It is not the business of our court system to determine the progress of those cases. I hear frequently judges say that they're under pressure from the legislature to move cases along. That, frankly, is an impermissible incursion upon the independence of the judiciary, and it's an important incursion, an impermissible incursion upon the right of litigants in civil litigation cases to determine the progress of their own cases. Again, it bothers me when I hear our elected circuit court judges saying that they are under pressure to move these foreclosure cases through, and they are taking the initiative to move cases through on behalf of the banks and institutions that file these cases when they should not be doing so. If the banks and institutions, the plaintiffs in these cases, don't want to move cases forward, they should not, and they should be under no pressure at all from the legislative branch to move them forward. Let's think about that in another context. What if our judicial branch were succumbing to pressure from the legislative branch to more quickly process criminal cases? And so the judges started leaning on prosecutors. You better start moving these cases to prosecution. Bring these cases of murder and whatever to trial and get them done. Well, the fact of the matter is that if the prosecutor doesn't want to move that case towards trial, he should be under no pressure to do so. Particularly, as is the case now, the reason why many of these cases are not moving is the plaintiffs are acknowledging that they've got problems with their own cases. So again, in that context, if the prosecutors recognize that they had major problems with their cases, and that were the reason why they were not moving them forward, the judicial branch should not be in the business of telling those prosecutors they must move them forward. One other example, in family law court, let us say that the judicial branch felt pressure from the legislative branch to clear out that family law docket. We've got all those divorce cases that are pending, and our judges are demanding that the litigants conclude those cases. And so you've got a husband and wife who are standing before you, and they're saying, Your Honor, we're not ready to move this case forward. We're trying to work things out here. And our judges say, I don't care about you trying to work things out. I'm under pressure from the legislative branch to clear my family law docket, and so you're going to get your divorce whether you like it or not. You see the problem with that. That is repugnant to our basic notions of justice, and we cannot allow that notion to go in any form of civil litigation or any litigation at all. The basic concept of litigation is that litigants have the right to determine how that case progresses, not the parties. So let's again analyze the parties that are involved in this legislation here, foreclosure. We got a homeowner. We got a bank with a mortgage. We got a title company. We have a condominium association, a homeowners association, a small number of cases, and that's important to understand. And we have a court system. Those are the 5 stakeholders in the legislation before us here. We have to understand the interests of those 5 stakeholders and why it is that they have interest in this. I think that the primary stakeholders that are pushing this at this point in time now are the title companies. And I'll get to that in a second. But, you know, I've posted some comments about this legislation, detailed analysis, thoughtful analysis of each section here that show that I'm trying to be productive and cooperative here and not just put up roadblocks. There's all sorts of technical problems with the language that exists throughout here. A big problem that we see in appellate decisions, and we see it in this legislation, is the blending and the inartful use of language. Legal terms are specific and definite, and we're flip-flopping and merging terms in this legislation that should not occur. We are blending together things like owner and holder beginning at line 200. That's impermissible. We need to be clear and tight with that because it has dramatic consequences for years to come. Going down to 224, again, we're blending together endorsement and assignment and making a mess of the 2 distinct bodies of law, the Uniform Commercial Code, which deals with the transfer of original notes, and that's done through endorsement, and then the real property body of law that deals with mortgages, and that's assignments. We must keep those 2 words and those 2 bodies of law separate and distinct because it's causing problems, as I found just recently in a trial. But looking at page 9, line 234, we see what is the biggest problem in this legislation right now. With the attempt to amend section 702.036, it's entitled Finality of Foreclosure Judgment. Now, let's understand something here. Judgments are final in all civil litigation cases, with the notable exception of an appellate case that I still take exception to now. But the fact of the matter is, in our civil litigation, judgments are final. And subject to very narrow exceptions, those judgments do not get overturned. So it's an important thing to keep in mind here that this legislation is seeking to address a problem that is vastly overstated. I can tell you as an attorney that attempts to overturn final judgments of foreclosure are very narrow, very rare. And so to address legislation which attempts to speak to a very rare circumstance is improper and impermissible. The fact of the matter is that in the cases where final judgments are attacked, those very rare circumstances where it occurred, they should be final to attack, or subject to attack. They must be final to, or subject to attack. And to change the law to not allow a homeowner to go back and make a challenge to regain that very unique and specific piece of property when you find the very rare circumstance of gross abuses that occur is an important diminishment of private property rights. We all must be about defending and protecting private property rights in this section here, which would eliminate a homeowner's right to challenge a judgment, is just bad law and attacks very fundamental aspects of our basic property rights. Again, in through 307 and 328, we see some bad language, some technical language in there that is problematic, that shouldn't be allowed to occur. Getting then into section 702.10, this is the so-called order to show cause proceeding. And the problem with this is it addresses the rights of parties in a way that attacks the fundamental notion of our ownership of property in this state. When you own a piece of property, you have a superior interest to all others who come to have any interest in that property, especially the bank who puts a mortgage on there, or lien holders who likewise attach a lien on there. There is a big screaming problem with this that's found at line 354 into 359, and that is it defines a lien holder as a party who could set this foreclosure rushed process in, the order to show cause process, and doesn't specifically define it as a mortgage holder or a condominium association. The language in there is slippery and dangerous, but what this language in here allows would be a lien holder to a contractor to put a $100 lien against your property and then put you into the hell of the order to show cause proceeding and take your property back in a very quick period of time. That is impermissible. I made some changes to try and address that language and make it specific to say that only a mortgage holder or a condominium or homeowners association, if at all, should be able to utilize these procedures. But frankly, as I got more into trying to tweak that language, I've come to the conclusion that that's just not permissible, shouldn't be possible. We did not give this right when we gave a mortgage. We as homeowners did not give this right when we agreed to our homeowners association conditions. And so the legislature, by passing laws, should not go and shoehorn this into there. Beginning at line 412, there's another huge problem here that I know many of our good elected circuit court judges are going to have a big problem with. This section should be called the Foreclosure Mill Relief Act of 2012, and I think it's going to be politically very uncomfortable for senators and representatives that would sign on to this, for the very simple reason that the general public right now is very upset with the foreclosure mills and the conduct of these proceedings, and frankly a lot of our judges are as well, and with good reason. But what you're doing here at lines 412 through 417 is providing an extraordinary windfall to foreclosure mill attorneys that would be paid for by homeowners. Here's the deal. It says that a 3% attorney's fee is reasonable in a foreclosure action, and query whether a $3,000 attorney's fee is reasonable for a $100,000 mortgage. I've heard many judges say that they don't find that reasonable at all, and so they will actually reduce down the $1,500 requested by foreclosure mills into something that they find reasonable. But where this is really bad is this legislation tells a judge that if a foreclosure mill comes before you in $1 million mortgage and no owner has filed anything and nothing has happened, you, judge, must grant that foreclosure mill $30,000 worth of attorney's fees. I know that judges will find this repugnant, and I think judges will have a real problem, as they should, in granting attorney's fees in the amount of 3% of the mortgage, or $30,000, when no work has occurred. This is an attorney's relief act that the general public rightly should go insane over, and it's going to be very politically uncomfortable for those legislators that that support that. There are technical problems in the language throughout here, beginning on page 16 as well. In this section, I find it problematic that We are making a legislative determination that litigants, citizens have waived their right to participate in proceedings. I think that has due process problems because you don't easily waive jurisdictional issues and right to contest proceedings. And I'm just not sure that language could be held up. Beginning at line 491, gets into another big problem with this legislation, and that is where the legislation seeks to force a homeowner to make payments to a bank or lender as a condition of coming into court and having her day in court. I find this to be constitutionally impermissible and repugnant to the basic notions of our property law in this country, especially in this state. Florida is what we call a lien theory state. I own my property. That has the most superior rights in all of our body of law, going back hundreds of years. And when I give a mortgage, I grant only a lien against there. And so to tell me now, as a lien holder, or as a title owner who granted a lien to a bank, that you must pay that bank as a condition of having your day in court is impermissible, and it's inconsistent with our notions of lien theory state as opposed to some other theory states, which would be title theory states. I'll post some additional law which makes the point of lien holder and owner more clear later. But another section in here which is very, very dangerous begins at line 639, and this is the so-called expedited proceedings of abandoned residential real property. Now, folks, we've got to understand that the law that exists will allow banks to timely proceed with their foreclosure cases, whether the house is abandoned or not, and we don't need this legislation. Again, we are passing, or we're considering legislation which addresses a problem which, frankly, doesn't exist, especially in this Sixth Circuit, but in circuits all across the state. Our judicial branch is doing a very good job with their scarce resources. And I can tell you from personal experience that if I file my case correctly, and I'm a responsible shepherd of that case, as I'm obliged to under my responsibilities, I can shepherd that case through our legal system without too much trouble. And frankly, the timelines to get things done are basically the way they've been for many years. The problem with this section, 702.13, is it sets up a very dangerous condition that already exists in the state. As many of you know, I have many cases pending across the state, including one very notable one in federal district court where a homeowner's rights have been viciously violated, and she's subject to a violation of her privacy because the bank and institution had decided that her home was vacant and abandoned, and they decided that it was their right to kick down the door and enter that property, not once, but 2 times, including once after the case is pending in federal district court. Now, I'm going to attach to this post here language taken from an order issued by a federal judge, magistrate judge in that, a federal judge in that case, where that federal judge found that conduct was extreme and outrageous, he, quote, sufficiently outrageous and extreme to support a claim for intentional infliction of emotional distress. That's important, folks, because as we consider this legislation, this particular section here speaks to extreme and outrageous conduct, potentially extreme and outrageous conduct, where banks and institutions are going onto property, making determinations that that property is vacant or abandoned, and then engaging in all sorts of dangerous conduct after the fact. I am concerned about the safety and security of employees and agents of the banks who are going onto properties right now, putting themselves in harm's way because of the very dangerous condition that exists when they step onto property, when they're trying to make determinations that property is vacant or abandoned. Folks, people are going to get shot. Agents and employees of the banks and institutions are going to be shot by homeowners who feel that they are being trespassed on, and it sets up a very dangerous condition. Senator Bennett had a piece of legislation which was far more responsible, and this would have law enforcement making the determinations that are included within Section 10 here. And if you insist on doing these determinations must be made by law enforcement officials, not by agents of the banks, many of them minimum wage agents of the banks, because this sets up a dangerous condition. The conditions that exist within here, or that they seek to demonstrate, are too light. If the minimum wage agent of the bank determines that there's rubbish or debris accumulated on the mortgage premises, or if they're delinquent in their homeowners association, those two conditions alone would allow the bank to go to the court and demand that a determination be made that the property is vacant, and then engage in these expedited procedures. Again, look at it. Line 662. If this minimum wage employee makes an affirmative determination that there's rubbish or trash accumulated on the premises, and number two, if they're behind in their HOA dues, the homeowner could be subjected to an expedited procedure, file an affidavit with the court, and then have the property deemed abandoned. Folks, the legislation as it exists is repugnant to our basic notions of property rights in the state. And I know our good Republican senators out there who respect basic property rights will not allow legislation to pass which destroys our fundamental notions of basic property rights. Those basic property rights, which are key and fundamental precepts of the Republican Party, are being attacked with this piece of legislation. And I know our good Republican senators out there don't want to go back to their districts during an election year and have to explain to the Republican constituency how it is and why it is that they signed on to legislation which attacks the most basic and fundamental elements of real property rights. I think that is politically very, very dangerous in this election year. And as a Republican senator, I wouldn't want to be back in my district having signed pieces of legislation like this and having to defend it. Especially when, as I've pointed out previously, there are some very real technical problems in here which are going to have this legislation subject to appropriate appellate challenge after the fact. It's bad legislation that shouldn't pass. I'm going to attach to this video some of the analysis that I engaged in along with some of the orders, and I hope that our good, considerate senators will understand that this legislation addresses problems in a bad way, that the problems that are demonstrated in our court systems can rightly be addressed with properly funding our court system, including in recognizing that our judges have, as they exist, the jurisdiction and the latitude they need to make appropriate decisions about attorney's fees that plaintiff mills are entitled to, about judgments, whether they're valid or should be final or not, and that the litigants in the legislation have the ability to make decisions how the case proceeds. Vote no on Senate Bill 1890 and support basic property rights and